and at this stage, we're less than 6 days before trial and say, well, they got it now. Too bad, so sad, no harm. Just give it to your expert. That'll happen in every case.
That's right. No,
Yes,
that's not.
yes. All right, I just want to say, good morning to everyone. Let's go ahead and set forth our appearances for the record. Start first with the plaintiff, then we'll move to the defense.
Good morning, Your Honor. Teddy Parker, Eric Pepperman, and we have Shane Godfrey here as our AV professional.
Oh, okay.
Good morning, Your Honor. Morning, Your Honor. Jim Cavanaugh for ETT1 LLC DBA Terrible Herbst.
Good morning, Your Honor. Corey Corporation and Dan Polsenberg for ETT1.
All right. Is what TV now?
Good morning, Your Honor. Joel Ledoux on Zoom for AffinityLifestyles.com, Real Water Inc. I also see my co-counsel Eric Freeman and Matthew Kaufman, whose PROHOC is pending. We don't anticipate speaking today, but wanted to wish the court a good morning.
Good morning, Mr. O'Doul. Anyone else on Zoom?
That's all for check-ins.
All right, thank you. Okay, let's continue on from where we left off yesterday, I guess a few days ago. Mr. Parker.
Good morning again, Your Honor. Your Honor, this could be a long morning and a long afternoon, or it could be a very short morning. Depending on the direction the court would like to proceed in.
I don't know if you've covered this, but I know there was a May 28, 2024 letter submitted to council.
Yep.
And we can go there. And specifically, what was the purpose, for what purpose was the letter sent? And because I remember we had some discussions regarding ESI protocol potentially. It appears to me, maybe I'm wrong, but this would be my impression that taking a look at the letter on the stated May 28, 2024, paragraph 5 potentially might deal with ESI protocol as far as search terms are concerned?
Yes, Your Honor. And so, Your Honor, when I sent this letter on May 28, 2024, it was my belief that Ms. Cozen O'Connor's firm, Ms. Rojas, would still be representing Terribles. And we were still concerned that we had not gotten all the documentation. Now, I've never professed to be clairvoyant, Your Honor, but given the inconsistent testimony we got during the evidentiary hearing, which was held during trial, we still believed that there were documents, commercials, promotional information that we'd not received.
All right, and here's my next question. As far as the promotional materials are concerned, for what purpose would those promotional materials be utilized at trial?
Perfect, Your Honor. And this was actually at the end of my presentation today, but you've jumped all the way to the back. So, Your Honor, when we were here the last time, Mr. Cavanaugh wanted to discuss the relationship of these documents to why we are here. And then he wanted to try to separate the Hunwartson case from this case. And so the promotional documents, John, are important because of our claims against not only Real Water, but also their relationship with their distributors and sellers. And in this case with Terribles, based upon the testimony of Anthony Randolph, was an intricate part of Real Water getting to the marketplace.
Okay.
And so they had the pump and pour was one of the promotionals, Your Honor. Pump and pour, and I don't know if you remember this from the first trial, but the pump and pour was a feature at Terrible Herbst. So when you're putting in gas, I don't know if you've ever seen
I know what you're talking about.
And while you're getting gas, you get this promotional on the screen there. It says, hey, while you're getting gas, if you want to come into the store and get something to drink, you can do it. You can push a little button and get a coupon. And you go take that coupon and you go into Terrible Herbst and you get that Real Water at a discounted price. That's a shared marketing approach, promotional approach between Terribles and Real Water. Real Water was giving Terribles water at a discount. They were sharing in the profits. It was a relationship. This relationship.
Now, under tort law, how would you define that relationship?
Your Honor.
I have thoughts.
You already have answers. Your Honor, that relationship is a relationship that's described in when you deal with any strict products liability case, when you have a chain of distribution. The one shared between your water and terribles. That relationship, that joint relationship, that endeavor to make more money through promotional and marketing activities between Real Water and Terribles, not only involved the pump and pour, Your Honor, it involved the commercials, it involved signage, it involved displays. It was, when you look at their business plan, that being Real Water's business plan, the incorporation of the marketing promotion efforts by Terribles is highly emphasized. And so we knew that there had to be something else out there because we weren't getting it. Now, what we didn't know, Your Honor, and no one would know this. No reasonable litigant would know this, because what we did is we sent written discovery out, and we got, in response to that written discovery, after a diligent search, we found no documents. That's what the responses were. Now, it didn't make sense given the testimony we have, and I want to give you a highlight of what Ms. Kayla Adams said, and then I'm going to get into this presentation so you can understand just why that letter we thought was important. Shane, can you bring up Kayla Adams' deposition?
And we're talking about the May 28th, 2024 letter.
Yes.
Because I don't mind telling you this. I mean, I went back and read the letter again. I understand what was going on here from a ESI protocol perspective, but it seems to me that the search terms, and I see there's names in it and so on, but for example, a search term of Real Water potentially would bring up documents, right? Search term of, I'm just kind of looking here, and there's some that just kind of jump off, drinkrealwater.com, alkaline water, and those types of things. And the reason why I bring that up, why weren't the search terms, and we'll get an answer on this, the ESI protocol run, and then those documents that specifically result from that ESI protocol produced instead of 270,000 plus documents.
Again, you're stealing my thunder, Your Honor. These
are things, I don't.
These.
Wait,
Can you answer the
no,
question?
you can write it down.
Write it
Wait,
down.
you can, wait, no. Gentlemen, I like everyone in the courtroom, but we have to follow. Yeah, we have to follow protocol, and you have to remember, I can't remember one time in 18 plus years, close to 19 years. Make a note of that, Mr. Cavanaugh, because you know I'm going to do what? I'm going to give you an opportunity. Right? I let everybody speak. I never shut lawyers down. Because I think it's important for me to be educated on what the facts are. It really and truly is. And I don't mind saying it. That's why I take a little bit more time for these cases, because I need to know what the facts are. I can tell you what the legal theories are, you know, as I learn more and more facts. That's not a big issue there. But I'm gonna give you a full and fair opportunity to respond to that, because I know you brought up ESI protocol issues before, and you said, well, Judge, we didn't really meet. I remember everything. So, Mr. Cavanaugh, don't worry. I'm gonna give you an opportunity, sir.
Much appreciated. Thank you.
I'm gonna give everyone. Same for you, Mr. Polsenberg. I always enjoy hearing from you.
Your Honor.
As long as we're making a record, I like Shane.
Yes.
So, Your Honor, what I believe this letter does, and when I sent the letter, I certainly could not have envisioned 271,714 pages coming on the eve of the discovery cutoff. But what I believe that letter would do was actually prompt a search that should have been done over 2 years before. Because we shouldn't have to tell our opposing counsel how to search their own records in order to respond to Rule 34 request for production, how to respond to requests for admissions, or how to respond to interrogatories. Your Honor, what we've gotten in the last couple of days, and I'm going to put this in front of the court after I get Ms. Adams' deposition testimony in front of the court. We received at 9 o'clock last night supplemental information from Terribles, less than 12, 13 hours from today. Here, we received at 7:21, again, supplemental responses. We received on the 14th supplemental responses. All indicating that the documents that we were searching for years ago, Your Honor, that should have been produced pursuant to 16.1 years ago, were not produced. And that's why I started saying this could be a very short morning, because when you compare this production, this untimely production, the lack of seasonable supplementation, that's enough for the evidentiary hearing already. Because now we can start questioning during the evidentiary hearing why they were 2 years late. Why did they give false testimony in relationship to documents that should have been produced? Why did they give false declarations, false deposition testimony, inconsistent and inaccurate responses to written discovery requests? That's what the evidentiary hearing is. I went over my notes from the last time we were here, and for some reason, it appears that Mr. Cavanaugh believes he can fight the evidentiary hearing and this preliminary motion proceeding. That's not what this hearing is about. This is just enough to show the court that there's a reason for the evidentiary hearing so that the court can then weigh the young Ribeiro factors given the testimony the court receives. But I want the court to see Kayla Adams' testimony. This is January 8th of this year, Your Honor. January 8th. Ms. Kayla Adams was the one who actually found the 11 pages of documents that were that we were informed of by accident right before the trial started in Hunwartson. And so Mr. Kemp took her deposition on January 8th. If you go now to page 9, I wanted to show that Mr. Cavanaugh was at that deposition. He, at that point, and Your Honor probably remembers this from when the Gallagher trial, he was representing Real Water of Tennessee, LLC. He was at that deposition. Now, if you go to page 30, Shane, thank you so much. Ms. Kayla Adams says that she had never heard the name Anthony Randolph, Blaine Jones, Brent Jones, Anthony Brown, all names this court probably recalls from the Gallagher trial. And you will see that we have dozens of documents that were produced most recently that involved those names. Go to page 52. Beginning at line 14, Your Honor. It says here, and more specifically, as we sit here today, we don't know if there were Real Water commercials on that desktop. Now, Mr. Kemp is asking her about these commercials, again, promotional marketing materials. And she says, I can't recall any. No, you can't recall any, but we don't know. That's his response. She says, no. One way or the other, do we? Again, Mr. Kemp has got, partial sentences here, but he's getting to the point. She says, no, I mean, all those files from that desktop would have been moved to my new desktop. Question, have you done a search on your new desktop for Real Water commercials? This is as of January 8, 2024. I have not. I believe Brad has, though, Brad being the IT guy. That's Brad Sexton, Your Honor, that I discussed at the last hearing, who said he never found the 11 pages or the 290 pages. And now we know he didn't find 271,000 pages. Then he says, Brad being the IT guy, correct. But you haven't done any search? I have not, no. Is it something that you can just enter a keyword and it searches through your files? Yes. So you haven't entered that keyword Real Water? I have not. Your Honor, January 8, 2024, months after we sent written discovery, over a year, couple of years since they've been involved in Hunwartson, and virtually a year since they were involved in this case, they haven't done, this cannot be considered a diligent search. We're not even searching the names of the company that is the first defendant in the caption.
I mean, I don't mind telling you this. I didn't know that was a testimony, but when I was looking at the letter and I was reviewing the points and authorities, just refreshing myself this morning, one of the first things that jumped out at me that if I was doing a document search pursuant to an ESI protocol, the first name I would put in would be Real Water.
And you don't even need, that's the thing. You don't need an ESI protocol. And I agree with you, Your Honor. But you don't even need an ESI protocol when you know that the defendants in the caption, the person that your company has been dealing with since the beginning, 2008 to the present, virtually, just look for the name. They didn't do it. And she confirmed it.
Objection, misstates her testimony.
So, Your Honor, I want to show you
But why, and Mr. Cavanaugh, you can answer this for me, but why wouldn't a simple real water ESI protocol be appropriate?
I don't know the facts at the time, but that wasn't the point of his questioning regarding Kayla Adams, an advertising person. And she wasn't tasked with doing that search at that time. So the fact that she hadn't done a search for real water and she's being deposed about commercials, that doesn't prove anything.
But my point is this, some decision maker, shot caller, or whatever you want to call it,
Okay.
should be making, when documents are being requested and you have items stored in a computer-like database, it seems to me the first thing you would do is just do a search, real water, what comes up before you get to even any specific names. And that's kind of my question. And I think that's a reasonable approach to it, because when I was reviewing the points and authorities again, that's the first question I asked myself, you know, and I will admit I've been out of litigation for over 18 years, but you know, documents are documents. I realize we store them differently, but that would be a really simple search. I don't know how many documents would come up, but at least we could all admit there would be efforts performed by doing that versus, you know, producing an entire database.
Well, I understand the court's point. I would just say there's more to it that I don't have the qualifications. And I know Teddy doesn't either, to say what's involved in searching a company's cloud records, individual workstations, laptops, enormous. There's 150 stores in Nevada, 164 in the Southwest, with different, you know, inputs to the system. I mean, Kayla Adams was asked about her role in advertising. I mean, she wasn't produced as a 30B6 witness on the search terms that were used to try to find promotional documents for real water. And that's all I can tell you for the moment. My participation in this case at the time was not related to Terrible Herbst, but I was there. I mean, I can tell you that.
Yeah, my thoughts on that would be this, I kind of get that, I understand what you're saying, but it would, and correct me if I'm wrong or not, but you know, Terrible Herbst, obviously with 150 stores, is a pretty big place, right?
Yes.
And they have probably different departments, but for example, do they have an independent marketing department? Do they have a sales department? Is there somebody that deals specifically with these types of issues, and they could search their databases to find out whether or not that has happened? But just as important too, we can't overlook the fact that when it comes to past history between potential entities and the like, somebody might know something about that, if you understand where I'm going on that.
I do, but again, you put your finger on it. You know, this is not a small company. It's a family-owned business, grown in Clark County very successfully because it served the needs of this community and with many employees. And she wasn't produced 30B6 on this issue. And I will just say that there's more to it than just going to your laptop and plugging in real water. I mean, eventually, and in fact, less than 10 days after her deposition, they produced 290 pages that they hadn't found before, not out of some nefarious failure to produce something or cooperate. They didn't find it. My understanding was because she was on a Mac versus another employee had looked and they were on a PC, and the archiving system was a bit different. You know, Your Honor, if we're talking about willfulness and intent and prejudice, so we haven't even got to.
I haven't gotten there at all.
Okay.
I mean, I
I'm
haven't.
trying to answer the question. It's very important, good question. It can't be answered just with Kayla Adams or why didn't we just look for real water? It's just not that simple.
Yeah, but understand this, I'm not going to any of those issues yet, but I'm just trying to find out, I'm on a factual finding.
Okay.
What's going on, what efforts were made, all those types of things. That's what I'm trying to find out, specifically, because in listening, to Mr. Parker, I guess it appears their theory is there was some sort of joint arrangement or some sort of joint marketing or joint this or that.
And a profit sharing, he said,
Yeah, I
which
understand
is
that.
absolutely untrue and has no support. Profit sharing is complete misrepresentation.
Yeah, but I get that, but I'm just telling you what his theories are. That's all I'm going. And under the law, we understand, and I always like to put everything into a bucket. That would be under joint venture theory. I get that, and I understand what that is, right? And there's joint venture and tort, we know that. Specifically, there's various forms of vicarious liability as far as joint venture is concerned. I understand the law. And here's the thing, I don't mind saying it, and many times why I spend a lot of time in these cases is, for the most part, like in the last case, I don't think anybody had to educate me on the law. Right? I need education on the facts. That's what I need. I need facts. I need to know what the facts are, because when I find out what the facts are, then I can start making decisions. Secondly, I don't mind saying this, and I know Mr. Parker's requesting the answer to be stricken, but I don't do that very often. And I don't mind saying it. And there's a lot of factors on the Johnny Ribeiro I have to consider. Sometimes I wonder what impact Bass Davis has on all this, when we talk about presumptions and those types of things. And I don't know, but and I know I have to go through a Johnny Ribeiro analysis potentially. I get that, and I will say this, and I haven't stricken many answers, but I will say this. When I've done it, the case has never come back to me, number one. And number two, I had one case where I did it, and it was an extremely well-developed record, and they settled for a lot of money, and it wasn't appealed. So you see where I'm going on that? And I understand.
I hear you.
And I don't.
This isn't that case, Your Honor.
Yeah,
I hope to show you documentation today.
But you understand where I'm going
now.
now?
Documentation right now.
Yeah, but no, but I'm gonna
It's
give.
called a partnership meeting among 200 vendors, including Real Water. It was called the 2021 terrible Herbst partnership meeting. And it was said to 200, this is a family-owned business that considers everybody that sells their good products with Terrible Herbst stores to be a partner in that loose
Well, if they
sense,
want to
not
say
in the
that.
technical sense. Not in the technical sense, Your Honor. They're not a partner with Anheuser-Busch. And they
Well,
work with.
it all depends, right? Actually.
Just keep talking. Just keep talking.
Well, can I approach and give you a letter?
No, you don't need to do anything right now. I'm gonna give you a full fair opportunity and talk to Mr. Polsenberg. But to say what you have to say. Right, but
I appreciate it.
But I never
Make
was.
this look pretty silly that you're arguing they're partners.
No, he's not arguing their partners. It's a slightly different.
Well, you argued profit sharing. Where'd you get profit sharing?
Well, I don't know,
I mean, where does that come
but you can point out that maybe there's no evidence of that to me. Mr. Parker will do his thing and I'll let you do your thing. But
Well,
But and all I can say is.
Respond and.
No, I'm gonna let you.
Kayla,
No, make notes. When Mr. Parker's done, I'm gonna turn the floor over to you.
It's gonna be virtually impossible after Teddy's gonna go for an hour and a half and I'm gonna.
I don't know if he will or
I can
not.
remember all this. Maybe not.
Well, that's what you write down.
Well,
That's what I do.
That's awesome. But if you stop in about 15 minutes, I'm gonna be good, but if you go an hour, I'm not gonna be good.
Well, don't worry about it. One thing I can say, Mr. Cavanaugh, it's hard to take notes when you're actually doing the talking. You've done as much as I've done. So far.
You know, you're wise and right. I'll agree with you, sir.
But everyone knows what I'm gonna do. I'm gonna listen. I'm not gonna rush to judgment. That's why I had you come back in today. Right?
I appreciate the opportunity.
Right?
Thank you for asking.
That's why I'm not gonna, I don't think I ever rushed to judgment.
I agree and thank you.
So, Your Honor, getting back. to
And I've been
where we
told I have really good records.
were, you have the best, Your Honor. And so,
We'll see.
That was from a Supreme Court justice. I was hoping.
I'll take that endorsement over anyone else. in the room. So, Your Honor, Mr. Cavanaugh would like to suggest that perhaps Ms. Kayla Adams is on an island, but she isn't. And we went through this in part when we were here the last time on the 7th. But Mr. Brian Breeden, and I'm glad you said what you said in the question, the way you asked the question. There are different departments.
Right?
Mr. Brian Breeden was the Vice President of Advertising and Marketing for Terrible Herbst. And he said, I understand that other employees have also conducted searches. I'm sorry, we start for his in terms of his search. Plaintiff's accusations are incorrect. I've conducted searches of my emails and I did not locate any communications, agreements or contracts with Real Water. Any. That's Brian Breeden. He also said, I also conducted searches, the marketing Dropbox for any advertisements, videos, or commercials of Real Water. He then says, I understand other employees have also conducted searches of emails, the marketing Dropbox, and other locations for communications or agreements with Real Water, or advertisements or commercials with Real Water, and none were located other than the 2020 Real Water coupon. Then he says, prior to my deposition in this matter, I spoke with Mark Walters, Terrible Herbst's Vice President of Purchasing and Sales, Christopher Kemper, Terrible Herbst's Vice President of Administration, and Brad Sexton, Terrible Herbst's Chief Information Officer. And each confirmed that they were not aware of any communications, agreements, or contracts with Real Water. Your Honor, Ms. Kayla Adams' testimony is in line with what each of these department heads said. In fact, the declaration of Brad Sexton, the Chief Information Officer, he says, I have conducted searches of Terrible Herbst's computer data systems. And it's on the screen, Your Honor. This is paragraph 3. Could contain information that could contain any communications or agreements with Real Water or advertisements or commercials of Real Water. I did not locate any communications or agreements between Terrible Herbst and Real Water. And the only advertisement I located was a still image of a 2020 coupon for Real Water that was produced by Terrible Herbst and is attached to plaintiff's motion. Now, this is what you'd started off this morning with, Your Honor. Paragraph 4. I searched Terrible Herbst's company-wide emails using the terms Real Water, Real and Water, and did not locate any communications or agreements between Terrible Herbst and Real Water.
And once again, what's the date of this
The
declaration?
date of this declaration, Your Honor, is, you can turn to the last page where you signed it, is November 22nd, I believe, or 21st. Yep, 21st, 2023. Your Honor, this is the Chief Information Officer, the head kahuna when it comes to their document retention system. And he used those very words and said he didn't find anything. So, Your Honor, at the end of the day.
Can I have the first page again?
Oh, sure. First page is, are you good?
Yeah.
Okay, perfect. Your Honor, each one of these executive representatives of Terrible Herbst ultimately said during the evidentiary hearing on January 24th, 7th day of trial, that they gave inaccurate declarations and inaccurate declarations, depositions and declarations. Now, if you could, Shane, go to slide number 2 of our presentation this morning. Your Honor, I want to give the court some chronological context to where we are in this case. Just because, and again, I don't believe we need to do all of this for purposes of this motion, because like Mr. Cavanaugh said, this is one of the things I did agree with him. He can't answer these questions. And that's why the evidentiary hearing is so important, because Mrs. Kayla Adams will, Mr. Brian Breeden will, Mr. Sexton will, Mr. Kemper will, and Mr. Walters will. Those are the people who will. Because, oh,
Is it a valid
Write down your
objection
notes.
that he's misstating what I
Just write it down,
said?
just write it down. So, Your Honor, Terribles was named in the Henry case 3/7/23. Their initial 16.1, May 16, 2023. All of these documents should have been produced then. All of them. All 271,714 pages should have been produced, in addition to the other 11 and 290 pages. We sent interrogatories and request production of documents on 10/25/23. And we sent a second, first set of RFAs, request for admissions, in November. We sent a second set of ROGs and a second set of request for production on November 3rd as well. And we got terrible answers to plaintiff's requests for production documents and plaintiff's ROGs on November 27th, 23, Your Honor. And those documents weren't identified, they weren't produced. And in fact, and I want the court to see this. I want the court to see what we have received most recently. And I brought copies for everyone, but they're all terrible Herbst documents. I'm sure he's familiar. Mr. Cavanaugh, one.
Thank you, sir.
You're welcome. Dan,
Yes, thank you very much.
one for you, Councilman Pro.
Yes, you may.
Now, the first document I gave you, Your Honor, is the defendant's terrible Herbst responses to plaintiff's request for admissions, December 4th, 2023. And I provide this, Your Honor, just so you could take a look at request number 1 and the response.
I'm sorry, I'm confused. Are you saying I served this?
Oh,
Oh,
Your
okay.
claim. I didn't say you had anything to do with this. I'm starting here.
Okay,
You'll get the relationship.
okay.
So
So,
write down your notes, your questions.
okay.
That's enough.
That's fine. No, I appreciate it. It's
That's
a,
enough.
it's a December 2023 document.
Okay,
Yeah.
that's right. And it says here, the request is admit the terrible Herbst aired real water commercials on gas pumps in Clark County, Nevada, 2016. Terribles denied, John. The next question, the next request is admit that terrible Herbst aired real water commercials on gas pumps in Clark County in 2017. Again, a denial. The same question, except for the years changed in request number 13 to 2018. Again, it's denied. And the same for 2019. These are denials we've got, things that we should be rely upon in this very case. Now, we received, Your Honor, on the 14th of this month, just 2 days ago, this document from Mr. Cavanaugh's office. Yeah.
Process.
Denied. Yeah. Now, these are, and it's funny that they come right after these motions are filed, Your Honor, but we'll get to that. This is terrible Herbst's second supplemental responses to plaintiff's fourth set of requests for production. And I want Your Honor to take a look at request number 24. And in this request, Your Honor, we ask for all documents from the Applause Network system operated by Terrible pertaining to video advertising in the time period of 2010 to 2020. Now, if you look, what we got was a bunch of boilerplate objections to the response. And now you see, Your Honor, that we actually have documents for the first time being identified by Terribles that respond to that request that was sent, Your Honor, in December of, November of 2023. So roughly 9-10 months later, Your Honor, and only after this motion is filed. And after we have this hearing before Your Honor a week before. If you go to number 25, Your Honor, the request is any and all emails, produce any and all emails to and from Kayla Adams referencing real water or real water advertising, including but not limited to video advertising during the time period of 2010 2020. So we get all of the objections. And discovery is continuing, and now we get this list. 2-page list of documents that should have been produced at least 9 months ago if you're using the request, but we would say should have been produced years before because of the relationship to this case, to the coordinated other cases. But we didn't get it in, y'all. Now, if you go to request number 26, it says any and all references to real water or real water advertising, including but not limited to video advertising during the time period 2010 and 2020 on your applause network. We get all of the standard objections that we got back in November of 2023. And now just miraculously, 2 days before this hearing, we get these responses with 3.5, almost 4 pages of new documents. Your Honor. Responding. That's what we get. That in and of itself would be enough to go to the evidentiary hearing. But we have more, Your Honor. This is what we got, which was served on us, electronically served on us yesterday at 7:21 p.m. Keeping in mind the one that was sent to us on August 14th was 5:53 p.m. after work hours for most people. You're welcome. Your Honor,
Yes, you may.
you know something, Your Honor? I only have 3 of these. Dan, let me give this one back. Okay. Your Honor, can I?
Yes, you can motion.
You can have mine afterwards. Right. Your Honor, I would have the court take a look at request number 1. We're gonna look at 1, 2, 3, and 4, Your Honor. So request number 1. Says, please produce true, accurate, complete copies of any and all video advertising or commercials for real water product, which were played on any gas pumps at any of your locations in 2013 to 2021. Now, I want the court to pay attention to page 6 of this document because what we have here is Terrible Herbst actually informing us at that time to refer to the Hun-Watson case. So when Mr. Cavanaugh was talking about, oh, why are we talking Hun-Watson when in the discovery done in that case versus this case? Because these cases were coordinated for discovery purposes, Your Honor, they were referring us back to Hun-Watson.
Objection. This states what the supplement response is. A supplemental response, Teddy, includes supplemental
Why are you
information.
not writing this down?
It's in
Cavanaugh?
bold
Why are you not
because you're
writing this down?
misrepresenting. to the
Wait,
court.
well, here's the thing, gentlemen, and we have to understand this, we don't have a witness on the stand. Consequently, there's no need to object, right? And you can point everything you want to point out to me. And I'm just looking at it from this perspective, and I think this is often overlooked, and this is always a great concern of mine when it comes to these types of motions, because at the end of the day, we all understand what our duties, rights, and obligations are under the rules of discovery, right? And I'm talking about the parties. And when I see blanket denials as far as information is concerned, as it pertains to discovery, by written discovery and or testimony under oath, then lo and behold, we have individuals recant their testimony or recant answers to interrogatories and the like. And then we have this type of scenario comes up, and understand, Mr. Cavanaugh, I'm not blaming you, you produced it. Thank you for doing that. But my point is this, and this is often overlooked because, and this is really, really, really important. I don't know what to do with it right now, but, and I think the courts, I don't think they really emphasize this enough, because when it comes to potential, you notice I said potential discovery abuses, factor number 7 under Johnny Ribeiro always jumps out at me. And what I mean by that is this: the need to deter both parties and future litigants from similar abuses, period, close quote. That's really overlooked because under our system of civil justice, parties have mutual obligations when it comes to discovery. And it shouldn't, and they should be truthful and forthright and just deal with the facts. But when it comes to not necessarily producing all the documents that would establish what the true facts are and the nature of the facts, that's a significant problem. I don't mind saying that. I just tell everybody that it is. It doesn't matter whether you're the plaintiff or defendant or whatever. Sometimes I don't know if, as a practitioner, that used to be a really big frustration of mine, because I think sometimes the trial judges will say, "Oh, you can just take the debt." You don't get do-overs, right? I mean, you just don't, because you should be truthful and forthright the first time you respond. You shouldn't have to catch them and then say, "Oh, too bad. Sorry." No, it doesn't work that way. And I'm not saying that's what's happened, but I just want to tell everyone this, that I'm looking at it in that framework, because that's one of the factors, and it's really an important factor. It really and truly is, and I just threw that out there because when this matter is reviewed at some level, I want the Supreme Court and/or Court of Appeals to understand what I'm concerned about, and because here we have a case that's been involved in litigation for a long time. I'm not blaming anybody for that, but I need to know why the initial responses weren't responded to, like in this case right now, today. I want to know why there was a need to potentially, and I'm not going to say it was, to change responses to interrogatories and/or deposition testimony.
Very briefly, Your Honor, I think the most important factors under Johnny Riviera boil down to willfulness and prejudice. I do understand deterrence is in there, but Justice Pickering warned in Bahena that deterrence is not enough for an extreme sanction.
And see, I understand and I respect that. But
and I figured you would, which is why I said it
Yeah.
in shorthand.
yeah, and my point is this, though, I think it's often overlooked. It really is, the deterrence factor. And actually, the deterrence goes hand in hand with willfulness. It does, right? I get that.
Well, if you're deterring willfulness, I got it. And deterrence is important, but if you're deterring negligence, that's more of an insult to the court system. There are alternative sanctions that apply there.
Well, example, Mr. Polsenberg, you don't have to educate me on that. That's what they talked about in Bass Davis. Presumption, yes,
Just take my record, because
Yeah.
I may not live through this hearing.
you're gonna live through this. And understand this, I mean, of course, I would have to make a determination as to whether it was willful, negligent. I get that, I do. But my point is this, and I don't mind saying it, one of the factors, where's it at? And I don't think it was in Johnny Ribeiro, whether there's where's that one at?
Which one are you speaking of? Your Honor?
I'm looking here. Willfulness. Oh, yeah, number 2. I always think of number 2. Mr. Polsenberg, the extent to which the non-offending party would be prejudiced by a lesser sanction.
Right.
Yeah, I mean, no, I get that.
I figured that was the factor you were thinking of.
Yeah, that's exactly it. That's it. But go ahead.
Thank you. And so, Your Honor, I brought this up because it says here, please see, and it gives a bait number and bait range produced in the Hunwartson et al. Case. And it gives not only the name of the case, but also the case number. Because these cases were coordinated and they were producing things in Hunwartson that affected all of the cases.
Right.
And so their obligation, in my opinion, to produce these documents go all the way back to 2021, October 15, 2021, when they did their first production pursuant to NRCP 16.1 in Hunwartson. So, Your Honor, in response to this, we get all of these documents, several pages of documents that were never produced or identified in response to written discovery before yesterday at 7:21 p.m.
Objections, incorrect. This was all produced weeks ago.
Your Your Honor, I don't know why we can't take notes. I do that for you. I will take notes while you're talking and only bring it up in my reply.
Just make an objection.
All right.
There's no need for objection. There's no witnesses here.
Well, I'm objecting because it's a misstatement of
Okay.
fact.
So, Your Honor, this is what we get.
Well, and here's my point. I mean, we can object, of course, Mr. Cavanaugh, I'll listen to you. But whether it was produced yesterday or a month ago, when was this case filed?
Thank you, Your Honor. And we had that on the first page. The Henry complaint was filed on March of 23, and the Hunworth's was filed in March of 21.
And
And they
so,
were in it and did their first response, 16.1 response, October 15, 21.
Right.
So what he's trying to refer, what Mr. Cavanaugh is trying to say is that these documents were produced as a supplement to the 16.1 on July 24th, less than 30 days ago. And now they're being identified for answers that enter to request for production of documents. My point still stands. They didn't supplement their responses to our written requests for documents until last night at 7:21. That's number one. Then we go, Your Honor, to request number 2. It says, please produce true, accurate, and complete copies of any and all contract or agreements relating to advertising of real water product. Now, this one, I want the court to pay attention to how they responded virtually 10 months ago. The first paragraph, which is the initial response, says at the end, after the boilerplate objection, says, responding party is not in possession, custody, or control, and not aware of any such contracts. That's what they said. That's what their response was. And you know why that was their response? Because they did not do what was required under Rule 34 or under Rule 16. And that's what Kayla Adams said. And then after an evidentiary hearing, that's what Brian Breeden admitted to, Mr. Kemper, and Mr. Sexton, and Mr. Walters. All of them agreed to that. And so now they supplement last night at 7:21 additional documents. And they do the same for number 3. So, Your Honor, I point this out to you to show again, these were documents within its custody and control. These were documents that were supposed to be produced roughly 10 months ago under this written discovery request, but should have been produced over a year ago pursuant to 16.1. Now, Your Honor, I want to show you what we got at 9 o'clock last night. And I brought enough copies.
Oh, thank you.
Thank you. That was good. Well done. Your Honor, this is Terrible's responses to plaintiff's Terrible's second supplemental responses to plaintiff's request for production set 2. Sent last night or electronically served last night at 9 o'clock p.m. Again, virtually 13 hours from today's hearing. I want the court to pay attention to request number 5, 6, 7, 8, and 15. So number 5, Your Honor, is a request, says any and all emails sent to anyone at drinkrealwater.com. Now, the point is, Your Honor, these words, which we saw in the earlier declaration, could have been searched in any one of those individuals' own desktop or laptop, or the company-wide computer system, which Mr. Sexton, the Chief Information Officer, spoke about, which he said he checked those words, which obviously he did not. Or if he did, he didn't produce documents that were discovered. The initial response to this, which was given over 10 months ago, roughly, says, after a diligent search and reasonable inquiry, responding party is not in possession, custody, control, and is not aware of any such emails. That's what they said originally, Your Honor. And now, this is the response. You see, as of last night, we have a page. We have a page, 2 pages roughly, of documents not previously identified in response to written discovery. Look at our request number 6. Any and all emails received by anyone at Terrible Herbst from the time period January 8th through March 21st, 2021. And just for the court's recollection, Your Honor, March 21, 2021, that is just a couple of days after the FBC, CDC, and Southern Nevada Health District required the recall, if you remember that. And it says from anyone with a root email address of realwater.com. Now, if you didn't get it the first time, real and water, we actually put realwater.com in the request. So this whole thing about an ESI protocol wasn't necessary because they said we'd already asked for them to be done. And they said that they already did it in after declarations. And Your Honor, all misstatements, all inaccurate statements, because now in response, and remember the original response is, and I wanted to read this into the record because this is what it was said in most of them. After a diligent search and reasonable inquiry, then it says again, after a diligent search and reasonable inquiry, responding party is not in possession, custody, or control of, and is not aware of any such emails. And then, Your Honor, we get a reference to documents. And then a reference back to the documents, 271,714 pages that were produced on July 24, 2024. Request number 7 says, any and all emails sent by Mark Walters. That was one of the declarants, Your Honor, to anyone that drank real water from the time period January 1st, 2008 to March 21st, 2021, or by Mark Walters to any real water employee at any other email addresses from January 1st, 2008 to March 21st, 2021. Again, their response is, responding party is not in possession, custody, or control, and is not aware of any such emails. And Your Honor, if you look at the next page, you have a full page worth of documents being identified. Request number 8, any and all emails sent by Mark Walters from the time period January 1st, 2008 to March 1st, 2021 that contain the search terms. And Your Honor, this is why I said I knew where you were going today, because these search terms were in our prior request. The words, the names, the email addresses.
I mean, to be candid with everyone, it didn't take rocket science to formulate what the search term should be in this case, right?
Exactly. So
That doesn't
Mr.
involve you
Cavanaugh-
getting in the rocket and going up with it either. I mean, anybody can make statements.
No, but I mean, what I'm saying, and let's be candid, when it comes to search terms looking for documents, it just jumped out off the page to me that the first term would be real water, you know, and that could pull up a lot of documents and maybe some of the key individuals. And that's not, I don't think you need a data specialist to come in and help you with that type of inquiry, especially when it's your own. But just as important too, and we can't overlook this fact, and we don't know it now. I shouldn't say we don't overlook this potential issue. We're talking about searches and protocol, right? What about knowledge of the individuals? That's another factor, and that's probably why we'll end up having an evidentiary hearing. You know, I mean, I'm just telling you the way things are going now. And here's a question I don't know the answer to, but I really kind of enjoy cases like this where we maybe can create new law. And here's my point. And this is a question for Mr. Polsenberg, because I don't know the answer to it. But for example, if you have a witness, a key witness and or employee that makes a denial under oath, what impact does that have on a determination or factoring in a determination by a trial court when we later find that it was untrue? Does that mean towards negligent or intentional?
Well, I'm sure Mr. Polsenberg will have an answer.
Yeah, I mean,
I also think it has to be in this case, Judge. This was the objection I had when we were here last week.
okay, but what about
This
a
is all
coordinated?
prior bad acts, and we've been sanctioned.
Okay, but what about coordinated discovery cases?
Well, no, the coordinated discovery is really to have a depository for documents. It's not that everything is automatically done in every case. Sure, did we say refer to what we produced in Hunwardson? Yeah, that's a smart thing to do, because there is a place where the documents are already sitting there and we can tell them to go look at it. It doesn't mean that everything asked and done in another case is done in this case.
Okay, here's my next question in that regard. If there are denials made under oath in a prior case, are you saying that the lawyers in this case and a companion case don't have a right to rely upon those denials in a coordinated discovery case?
You mean discovery request denials? He's relying on denials done in this case.
Okay, but also in the other case too. Okay, then why do we have coordinated discovery?
We have things under oath.
Right.
It shouldn't matter what case you're in. You should tell the truth no matter what case you're in, Mr. Polsenberg.
They've asked, thank you, Teddy.
But you don't have to answer that right now, but I'm one, and I understand you're saying, well, look, Judge, it kind of depends on where the denial is, but does it really matter if, you take an oath in every case to tell the truth?
Look, the problems we had in Hunwardson, we don't have here. The 290 documents were produced, in fact, in this case. They are trying to get you prejudiced by conduct in another case. They are, Judge. You can say you won't be prejudiced, but they're trying to get you there.
Well, I understand that, and
But
here's
let me
a,
finish my sentence.
and then I'll finish.
Prejudiced by conduct in another case we've already been sanctioned for, and that I don't see in this case.
And so are you telling me that I should ignore conduct in another companion case in making a determination in this case?
Yes, because no, if we complete, Judge, if these were totally separate cases, and I say they are, it doesn't matter to you whether something was done in another case. You can't penalize us in every case for that. You need to look at this case.
Okay, and so I'm looking at this case and I'm looking at, are the discovery responses, Mr. Parker, he's been reviewing, those are in this case, right?
Yes.
Okay. So
And I'm so happy that he's produced, going to these and going to them. Corey's been telling me, sit down, Dan, just stay seated. But it's, I complained last week about the terms of the indictment. He's bringing these things in today. He's bringing these things in the other day. The ground keeps shifting under me what their complaint is. So I haven't objected. I'm fuming, but I haven't objected, and we'll let him present all this, and then you can decide what the terms of the indictment are. I said terms of the complaint. What's the indictment where you're issuing an order to show cause that we should not be sanctioned? And I don't think they've done it yet, Judge. They can't just come in and say, look, here's things that weren't produced. Then they were produced. Woo, that's bad. That's not enough to get an extreme sanction. If you want to sanction us $10,000 for producing things late, and then I can get back out of the case, that would be wonderful.
Yeah, well, here's the issue with that though, is this, and this is often overlooked, I think from a sophisticated discovery perspective. We're going to trial when?
October 7th.
Right, and so, and here's my point, in today's August 16th, is that correct?
August 16th, that's correct.
Okay,
That's
and discovery's closed
closed next week.
next week. How do
You
we?
guys really should go on the road.
No, but he's answering my questions, and that's kind of my point. My point is this: what do I do? Because it would be one thing, say hypothetically, the documents, this whole, I'll call it a dust up for now. Is that fair? A whole dust up.
Well, I don't know. I'm still focusing on the word dump from last week.
Okay,
That's
well,
okay.
I corrected that, but dust up. That's
You said it, Judge.
okay. I did, but 270,000 pages of documents are a lot of documents.
And we're gonna get to that when Jim gets the chance to talk.
Yeah, but that's still a lot of documents, Mr. Polsenberg, and we can agree on that one point. But here's my point. What do you do? Because I have to factor this into whatever decision I make. Say hypothetically, there was a discovery violation or alleged violation or a problem or a dust up, I'll call it that, as far as production of documents and specific testimony, and it was done a year ago. Okay, that gives me a lot more flexibility as to how I proceed from a decision-making perspective, because, for example, there could be enough time to cure. You see where I'm going on that?
I do, and here's what I think. I think you need to look, which is why I'm saying you need to look at willfulness and prejudice up front and not deterrence. If you say, look, it's early enough, just give these documents to your experts. If they haven't been deposed, they can be deposed. If they need to come up with a new opinion, we've got time to get a new opinion. If you're saying they can't have the time to review these documents, then you're looking at a different issue. So that's the stuff you need to address threshold.
But those are all the issues I've been considering. And that's why I brought it up, because here we are, less than 60 days before trial, right?
Judge, and they made the motion, they presented a certain thing. It keeps shifting now. They're the ones, I think, who are trying to make it bigger. The issue before you can handle from a prejudicial point of view by saying they've got the information now. They've got the information that we ran the request that they asked us to run, even though we provided the database for them to be able to run the searches themselves, and they didn't. Under those circumstances, this can all be handled. But if we're going to be distracted by this and have an evidentiary hearing, I think it's designed to consume the amount of time we have left and the oxygen in the room so that the issue becomes critical only through strategic raising of issues.
Why should we have to recalibrate discovery at this stage?
I don't think you have to.
Yeah, well, that's what you just asked for. You asked for a recalibration.
You got the information now. They have to come in anyway. They're doing an evidentiary hearing and say, here's the information we have now. Here's how we would have had to have used it.
This is why, and I understand which justice was it in the other case?
Pickering.
I understand her point, and she talks about prejudice and those types of things, but that's why I think in many respects, it's overlooked the need to deter future conduct. Because if we're going to just sit back as a trial court and at this stage, we're less than 6 days before trial and say, well, they got it now. Too bad, so sad, no harm. Just give it to your expert. That'll happen in every case.
That's right. No.
Yes.
No.
Yes, well, that's how I look at it. I
Okay,
mean,
fine.
I don't mind saying
So,
it.
But then consider a sanction geared only to deterrence. And it isn't something that affects the trial in this case.
Well, see, here's the thing, and understand this, and Johnny Rivera, we have 7 factors, and just because I discussed the impact of potential deterrence on future conduct, doesn't mean I've said, look, I'm not going to consider degree of willfulness of the offended party. I'm of course consider that. I'm not going to consider the extent of the non-offending party would be prejudiced by lesser sanctions. I'm going to consider all those factors, but I do think when you look at factor number 7, what it does is this, and this is really a significant issue as far as I'm concerned. If you start producing documents that you potentially had an obligation to produce maybe a year before a year earlier or 2 years earlier, whatever it might be, and you produce those documents 60 days before trial, that's an issue, and I don't know what I'm going to do with it. And I want to make sure the record's real clear. I'm not saying, and this is to the Supreme Court, I'm not saying that I ignore the 7 factors in Johnny Rivera. I'm saying this, that I feel that in many respects, and I can say this as a trial judge, that factor number 7 is overlooked in that what happens when documents are produced at a late date that should have been produced earlier, and you're less than 60 days before trial. Under those circumstances, do you get a do-over? And that's basically what we're talking about here. And so in order to emphasize the duties and responsibilities as it relates to discovery amongst parties and their joint obligations, I feel that you have to consider that, right? Because if you don't, then everyone would say, oh, well, Judge Williams, this list should produce it 60 days before trial, go take some depositions and things like that. That's not how our processes work. And that's kind of my
still
point.
in the discovery time.
I understand, but
But the way we're going, we're not even gonna get to an evidentiary hearing before the discovery time period cuts.
Oh.
I
We
think,
can do it next week.
But here's my, no,
We can't do it.
no, but here's my point. We can talk about that later. I haven't made a decision on that, but my point is this. That just underscores my concern because the close of discovery is next week.
Judge, deterrence is in every case, all right? Anytime somebody produces something late, I'm gonna have a district judge say to me, well, we can't put up with this. We need to make an example of this character so that this doesn't happen in any other cases.
What I have to look at, well, that's something I should consider. I don't mind saying it. But secondly, I have to look at the reason for the delay.
The reason goes to willfulness and prejudice.
Exactly. So you
Yes.
notice how I
But-
didn't overlook that. I have to look at the reason for it. Yes, I have to.
But I
look-
do, and you and I get into this discussion in every case.
We
I
do.
know, I'm not saying you're overlooking those.
Yeah.
But Judge, this transcript's pretty clear that you're focusing on deterrence. So I know you will look at the two main factors, and that's why I say I boil all of the 7 factors down to 2. Thank you, Your Honor, and that'll teach you for asking me a question.
I always like to listen to you, Mr. Polsenberg. But
Say something?
yeah, absolutely. And it's really important because I do feel this is overlooked when it comes to, and that's why I use an example. This was a year ago. Slightly different scenario, right? But we're less than 60 days before trial. The discovery cutoff is in a week. And but Mr. Pepperman, go ahead, sir.
Your Honor, I just want to add one fact to the conversation here in terms of willfulness and deterrence. Because it's not just, oh, we found these additional documents at this late stage and here you go. This goes back to the requests that were denied in November of 2023. And remember, the most important fact that we haven't been discussing is the inadvertent disclosure of the 290 pages. They didn't produce those documents. They inadvertently copied us on an email that included those documents. That's what tipped us off that all those discovery responses, those prior declarations saying these documents don't exist were wrong. That's what the evidentiary hearing was on Wardson. That's when they all came in and said, oh, this was inadvertent. We didn't know. They were in an archived email. We didn't think to search that. Now we've searched it and you have everything. You have everything. They've said it under oath in relation to those 290 documents. Last time this came up and they said, oh, inadvertent, not willful, don't sanction us. It was unintentional. Now we found them. Now we've given you everything. And then in this case, they supplement their responses to just reflect those 290 documents, nothing else. And then July 24th, we get 270,000 more pages.
Okay, this is what I hate about stream of consciousness allegations. That's the argument they made in Hunwardson, because we didn't produce them in Hunwardson. We produced them in Henry, and that's the case we're in now. Sorry to interrupt.
Okay, and no problem. I have a question in that
February.
regard. I have a question in this regard.
The 290 pages, not the 270,000 that we're talking
Which
about today.
they engineered would
Okay.
be overbroad and not relevant.
All
I'm
right.
gonna show you documents from them that
Here's a,
said, give us your overbroad production and we're gonna let our experts do this reduced search. That's a July letter, Your Honor.
okay, and that's why I haven't made a decision yet at all. But wait, I'm trying to get the facts, but here's a question I have, and Mr. Polsenberg can answer this more for me. Are you saying that in a coordinated discovery case such as this case, and the deposition is taken of a witness in the Hun-Wardson case, is that the other case?
Yes.
Okay, are you saying that in this companion coordinated discovery case, the plaintiff would have to take that deposition over again, or can they rely? Okay, so they can rely upon that deposition testimony in this case.
Well, if we're talking about the underlying merits of the case, of course, but what they're coming in, and I haven't objected today and said, no, that evidentiary hearing took place in that other case. I'm saying that discovery violation took place in that other case. This case has been handled in a different way.
Yeah, and what I'm really trying to focus on when it comes to relying upon, for example, in this case, I mean, in the Hun-Wartson case, there were specific denials made regarding the documents and depositions. Are you saying, and I just want to make sure, that doesn't the plaintiff have a right to rely upon those specific denials that were made by key witnesses in the Hun-Wartson case?
No, and you notice today, they're coming in with the separate discovery requests in this case.
Yeah. But I'm talking about that. I'm not focusing on that. I'm focusing on the deposition testimony that was taken under oath in the Hun-Wartson case.
If the deposition testimony is, we have this contract, they can use it. If it's that, here's why we answered the question in Hun-Wartson the way we did, that's irrelevant. That's irrelevant, Judge. You need to be focusing on what happened in this case.
But that's well, where's the line of, where's the distinction? Where's the distinction?
Your Honor, I have to follow up on what Mr. Polsenberg said. Is he trying to suggest that in a coordinated case, you can lie or misrepresent the truth to get around one case, but on the other coordinated case, that lie can't be used against you when it comes to discovery? You cannot be saying that. You cannot be saying that, Judge.
No, I'm not saying that.
Okay,
You've known me 40 years. There's no way on
I
earth.
just want to make sure we're clear. That's
Okay,
all.
We can take it item by item. I haven't interrupted Teddy because Teddy's gonna call me old and tell me to take notes. So we will handle it as we go along. A lot of the stuff he said today, you should be paying attention to. He's been much more focused. I don't want him to hear this. He's been much more focused today than he was last week. So, you know, we could be out of here today, but we haven't even, I share Jim's frustration. We have a story to tell and you haven't heard it yet.
And
I'm not saying you won't listen to it.
I'm gonna listen to that.
I hear you.
But it's law in motion. Remember this, one of the things I've done a little bit differently, because normally we don't ping pong. And I've been permitting ping ponging, you know, and I think it's important as we kind of go through it.
Well, you know, in my day job, people only get 15 minutes, so I don't have to sit there as long waiting for the other side to finish talking.
I
I'm
understand.
saying that while I'm watching you and Jim go at it.
But this is what's important too. I mean, I'm looking at this and we can't overlook the thrust and scope of the request. And I always feel it's a little better to spend more time than not enough time to make sure I'm truly educated on what's going on here. That's all.
And I understand what you're doing, but my other frustration is I don't know what the request is. It keeps changing.
I think the request now, it appears to me, that evidentiary hearing.
Absolutely.
Yeah, that's,
Well, I need to know what the evidentiary hearing is about. I need to know the specific things that we're talking about. But you need to go through today first to say whether it's enough to have an evidentiary hearing. It's not enough that there is an alleged discovery violation. If it's a discovery violation where you say, look, you know, you were late, I'm going to hit you up with a monetary fine.
I got you.
Thank you, Your Honor.
Okay.
So, Your Honor, when we left off, we were going through request number 8. If you could put that back on the screen for me, Shane. Request number 8 says, any and all emails sent by Mark Walters from the time period January 1st, 2008 to March 21st, 2021 that contain the search terms real water together, or drinkrealwater.com. And again, the response is, after a diligent search and reasonable inquiry, responding party is not in possession, custody or control of, and not aware of any such emails. Your Honor, the reason I'm putting these in front of you, because you don't have to take my word for it. This is their own responses showing that they gave inaccurate responses to request for production of documents. And then they list, Your Honor.
And what was the date of this production again?
The original production, Your Honor, can you put that back on screen, page 3 of our presentation? Bingo, there we go. So, Your Honor, this is a response to our second set of requests for production of documents, and our second request went out March 3rd, 2023. So 11 months before the trial in this case was scheduled. And they did not respond to it, other than to say they didn't have anything that fit those search terms. And we know
What date,
that.
what date again was that? Once, is that
We
11?
sent it November 3rd, 2023, and their original responses to our second set of request for reduction of documents is 12/4/2024. So roughly 9 months ago.
Objection leaves out the first supplemental response, February 2024. We listed the 290 documents that were produced
So
in Henry, January 2024.
listen, Mr. Cavanaugh, again, because I believe in being completely forthright, I have, when you provided the 290 pages, it doesn't equate, it doesn't absolve you of having failed to produce 271,214 pages last month.
That's
Okay.
a different topic.
So, Your Honor, if you look at now the responses, we have 4 pages of documents identified. When I say 4 pages, each page has, I don't know, 15 to 20 documents identified, at least, that were not identified in responses to our written request back in December of 2023. And then if you go to number 15, Your Honor. Again, we ask for any agreements from January 1st, 2008 to 21, and we're referred to the July 24th production. So that was served at 9 o'clock last night, Sean. So in the last month, we've gotten 271,714 pages of documents. And we got another 1,498 pages related to their insurance that we had not had before. Your Honor, the 4th supplement was sent on July 24th. Then we have the 14th, August 14th, we just went through, it was served electronically at 5:52. The 3rd, I'm sorry, terrible supplemental response to the first set of request reduction last night at 7:21. And then the responses to our second set of request reduction documents at 9 o'clock last night. Close of discovery is next Friday. Dispositive motions and motions in limine are required on August 26, 2024. Your Honor, just by way of a visual, this binder.
So in 10 days, motions and limine are.
Exactly.
And
And
dispositive-
dispositive motions. Your Honor, just by way of a visual example here, on this desk, this binder has about 550 pages. I filled it to the brim. It's about a 4-inch binder. 271,000 pages of documents couldn't be held by all 3 of these desks here. And they would expect that we would have to go through all of those documents in time to complete discovery, prepare preliminary pretrial motions in forms of dispositive motions and motions in limine, and then somehow incorporate that into everything we've done to prepare this case for trial. It is impossible. We don't know. I don't think there's a firm in town that has the bandwidth to do that. And even if they did, they wouldn't have time to redo all the depositions, redo the discovery. It's impossible. And they knew it when they did it. So, Your Honor, if we go to the depositions, next slide, please. These are the depositions that we've taken at this point. It's too late to do any new ones. We got Chris Kemper, October 3rd, 2023. And I put that there, Your Honor, because these documents should have been produced in May of 2023 so that we could have questioned him on those documents, but we didn't have them. Brian Breeden, November 23rd, 2023. Again, we didn't have the documents. We did the written discovery expecting to have those documents if they were available, but we were told they were not in their possession. They didn't have them. And so that's what we got. Anthony Randolph, December 11, 2023. Kayla Adams, which we just went over, Your Honor, January 8, 2024. Next slide. We have the evidentiary hearing, Your Honor. And these people from Terrible Herbst, Christopher Kemper, Executive Vice VP of Administration, testified. Brian Green did, and I've given you excerpts from his testimony. Mark Walters and Brad Saxon, Chief Information Officer. Next slide. They all gave declarations saying that they've searched it, they've produced it all, 290 pages is it, there's no more. There's nothing else. That was as of November 23rd. I'm sorry, November 2023, they all signed their affidavits. Mr. Kemper did a second affidavit of January 19, 2024. Indicating under oath that everything's been produced now. Keeping in mind, we had all that written discovery out there. And also keeping in mind, Your Honor, during the evidentiary hearing, they indicated that their discovery of the 290 pages related to this case. So if they found the 290, they certainly should have found 271,714 pages in addition, which they didn't produce at that point. And Your Honor, I'll just refer you quickly to the evidentiary hearing, just so you can see the references to the Henry case. If you could, Shane, could you go to day 6 of the trial, January 23rd, 2024, for the court?
Day 7.
By you, day 7. No, don't worry about it. I'll get to it a different way. Go to the next slide. So, Your Honor, after that, December 4, 2023. This was what Mr. Breeden, the other members, executive staff, go to the next page. This is what we informed Judge Kishner of in terms of all of these witnesses giving false responses and discovery. Now, I bring this up just because I want to draw a line of distinction between Hun Watson in terms of why we're here today, because that's something that Mr. Polsenberg said in response to one of the court's questions. The 290 pages was a problem that was produced late. The 271,000 pages is what prompted us to be here. When we originally filed our motion, it's because we knew based upon, or we believed based upon the deposition testimony and the written discovery, all documents had not been produced. And we were determined to be right. And we were also determined to be right in terms of their responses to our written discovery. That's why we are here. Now, the continuation of false testimony, both under oath in the courtroom or in declarations or in responses to interrogatories, that is a stream of discovery abuses that's culminated now with this 271,000 pages. If you could, you do?
Can you refer to the page you've shown the court right here, right now, specifically what is this from?
You like that? Yeah, could you go to the preceding page? It's from our your benefit. It is, go back to the first page so you can see it. Can you see it now, Jim?
I cannot, maybe
It's
just
sitting on
read,
that screen in front of you.
read in the record, the volume of the day of trial or the hearing date of that page you just showed the
When-
court.
Well, it's electronically filed December 4, 2023. There was our initial
No,
it was-
testimony from the hearing or
it-
from the trial that was quoted there. Go back to that page and you'll see the quote. I just
Okay.
don't see the top of the page.
Yeah, this is taken from our plaintiff document referencing the declarations we talked about earlier.
No, this is Charitable Herbst's reply in support of its motion for summary judgment filed in the Hun Watson case. Terrible Herbst moved for summary judgment on plaintiff's punitive damages claim and said, you guys have no punitive damages claim. There's no evidence because there's no evidence of the commercials. And that's where this is from.
Remember, are you fine with that, Jim?
Yeah, thank you for clarifying that.
No,
Eric.
no worries. I appreciate that, Eric. Now, Your Honor, we also attached interrogatories, which we thought were persuasive in that case, but it's a continuation, and we wanted to show it for purposes of this case. The interrogatory number 6 says, state whether or not any of your employees had any communications with any employee of Real Water Company in the years 2018, 19, and 20. If so,
Which
state.
case is this?
This is on Morrison. This is on Morrison. And if so, state the name of the employees of each entity and describe.
We've been sanctioned for this. I think we should focus on what took place in this case.
Okay, so Your Honor, they indicate the answer is no, that they've had no communications with anyone from Real Water for 2018, 19, 20. The reason I bring that up is because in this case, we asked questions similar to those by Mr. Kemp of Ms. Adams. We asked questions during the evidentiary hearing, and it's been determined that there were communications. So when you're responding to our written discovery, each of those individuals, Mr. Sexton, Mr. Walters, Mr. Kemper, and Mr. Breeden, could have easily checked their emails using those search terms that we had in our written discovery to find out that there were communications. That is the point. And now we know that there are, because now in these most recent responses in this case, they've identified those documents that actually prove that their original responses were incorrect, that their searches were not done correctly or done at all, and that their sworn testimony was false. That is the point, Your Honor.
Objection, mistakes.
So if you go to the 14th slide, Your Honor, I want you to see right there that Mr. Kemper was the one who actually signed this verification. Same person who gave 2 declarations and a deposition. And despite all of that, we get these 271,000 pages. Your Honor, what Mr. Pepperman was talking about earlier, how the 290 pages were discovered. Go to the next slide. This was the email that tipped us off to the 290 pages. It was an email that Brianna Switzler was actually identified on that, you know, apparently someone made a mistake, but it identified 11 documents. Next page. These are the 11 pages. And once we got those documents, we said, wait a second. And they said they discovered these documents looking for documents related to the Henry case, Your Honor. And if you go to page 18, I'm sorry, slide 18, this is what it says. That this is Cozen O'Connor, Terrible Herbst prior counsel. Said during searches for documents responsive to Henry, request production using the term drinkrealwater.com. So they did that search and found those documents and yet did not produce the 271,000 pages back then. Now, when Mr. Cavanaugh decided to throw this document, the May 28, 2024 letter, perhaps he was not aware of that letter from Cozen O'Connor. Perhaps he was not aware of the written discovery that says real water, drink real water, search these terms. Perhaps he wasn't, because if he did, he would have found this document to be so moving, in my opinion. Because this is what Terrible Herbst's own counsel said. Your Honor, these are coordinated cases. She was looking, or Cozen O'Connor and its staff were looking for documents related to our request for production documents, which we've gone through now. And they did not produce these documents and should have. And the reason why we know they should have, because they now have been identified in responses to our previous written discovery requests from last year. That's why, Your Honor, the next document, and we've discussed this, would be the videotape deposition of Chris Kemper. Again, I don't believe we should go through those right now because we discussed them, but I want to give you just a snippet of one of Brian Breeden. If you can go to page 22. because I think this is for the evidentiary hearing. This is his deposition taken November 3rd, 2023. Next page. Question is, have you heard the name Brent Jones? I have not. How about Blaine Jones? No. Amy Jones? No. Anthony Randolph? No. Your Honor, at the evidentiary hearing, he agreed that he had misstated and that he remembered that, at the evidentiary hearing, under oath in front of Judge Kishner, that he actually gave false testimony. And the same was done for all of them, Your Honor. And I went through last week how they said or admitted to having given false declarations and deposition testimony. Your Honor, that testimony, when they told us at the evidentiary hearing, the 290 pages was it, and we still didn't believe them, we had a reason to not believe them. Because now, in this case, we got 271,000 documents. We got, in the last 3 weeks, in fact, last night, we got 2 different supplements. We got one on the 24th that should have been produced virtually, I believe, since May of 2023. And given that they're coordinated, I think they should have been produced since October 15th, 2021. One of the things we found, and I want to show this document because this is a document I thought was persuasive in terms of promotional and promotional materials or commercials. Could you go to slide 28? This is Amy Jones. Amy Jones from drinkrealwater.com. This should have been found originally. I would like to touch base with you and see if there's any opportunity to put the real water commercial on the terrible Herbst gas pumps again. Not for the first time, but again. Now remember, all of these witnesses denied any commercials. And now, as of July 24th, 2024, we have proof. I wanted to hit this, and this is one of the reasons why I said to Ms. Cavanaugh, he should probably wait till I was finished. Go to page.
Before you go, could you put the bait stamp in the record for this one page of a string email?
PH002407.
That's the Amy Jones email?
Is that it right here, Shane?
You see it at the bottom, 2407?
Do not on the screen. What's the?
Right.
I
full
see
bait
it.
stamp?
You don't see?
And this thing is overlaying it, my bad.
Okay.
Is
So
that the same one you showed with the 2 pop-ups in it?
Polsenberg, I'll get it for you. Or she'll get it.
Well, there was one with 2 pop-ups and one of the pop-ups obscured the base number.
So what Shane typically does is show the big one, the full
Right,
page, and then he shows the paragraph I want to see.
Right. He's
Got
not,
that.
he's not showing the rest of the response from Charles.
Got that. I think I'll talk to you later, Shane. I think there was a base number I missed.
All right. So, Your Honor, this is what Mr. Cavanaugh was speaking about earlier. This is an email inviting Real Water to a terrible super supplier partner marketing meeting. And he said there was 200 people or so invited. The point is, Your Honor, that document was produced during trial in Hunt-Warrenton. And given that they were able to find this document that has Real Water and Anthony Randolph, they should have found documents that are now being produced the day before this hearing, or being identified in response to written discovery. Now, go to exhibit 35, please. Not exhibit 35, but slide 35. So this is what we have in terms of the facts of this case, John, versus facts in the CCSD case. There were 2 false affidavits in that case, and they withheld 500, it was actually 1,500 documents in that case, but 750 of them were particularly responsive to issues in the case. They're all related, but some of them dealing with change orders and such. But in this case, we got actually 5 false affidavits. We got 290 pages that Mr. Polsenberg and Mr. Cavanaugh like to speak about in terms of what was discovered in Watson. But, go back. We have, in this case, 271,000 documents disclosed on July 24th, after plaintiff's motion for Rule 37 sanctions, not before but after. And we still don't know that there are additional documents outstanding. Next slide, please. We also have, in this case, failure to disclose witnesses during the discovery period, misrepresentations and deposition by Mr. Kemper and Mr. Breeden, misrepresentations and answers to interrogatories, and failure to comply with NRCP 34. Next slide, please. In the Valley Health Systems case, Your Honor, you're very familiar with that case. They failed, the defense counsel and the defendant failed to identify 2 nurses, and the witness statements those nurses provided to the police department. And they contested summary judgment based upon not providing that information. In this case, we had several terrible employees who failed to produce documents related to their own laptop or desktop, their emails, failed to disclose witnesses that are identified in those documents, failed to produce documents timely. I'm not going to keep saying it, you know the number of documents. Next slide, please.
Can you go back, Teddy?
Sure. Can you go back, Jane?
The facts of this case.
Yeah.
Bullet point 3 is saying this should have been produced October 15, 2021.
Yeah, we believe that all of these documents should have been produced as a part of coordinated discovery efforts in this
When
case.
Henry hadn't named Terrible Herbst as a defendant until March of 2023. How could this? These things don't apply.
But you can clearly bring it, you know,
It'd be
go
great
there.
if this was in writing, so we had a target to look
Yeah.
at
So,
ahead of time.
Here's an important point. I just want to tell everybody this, we're gonna break at noon. We might be here all afternoon. Just want to let you know that, and we're not rushing to judgment. There's thoughts I thought about, and I understand Mr. Polsenberg, for example, reminded me of, I guess, the 2 key factors Justice Pickering felt were important. But, when I sit back and I look at Johnny Ribeiro, it says, quote, "We set forth a non-exhaustive list of factors which the court may properly consider in deciding whether dismissal is the appropriate sanction," period, close quote. Now, and here's my line of query. What if I'm not considering dismissal? What if I'm considering other factors or other issues? And you don't have to answer that right now. You don't have to answer that right now. Yeah, go ahead.
Oh, well, yeah, because remember, that was the plaintiff who had manufactured false evidence in Johnny Ribeiro. That's why it talks about dismissal. So yes, it is looking at, but it's also looking at, you can tell from the sanctions, alternatives to the ultimate sanctions.
Oh, yeah, well, that's my point. What if I'm not looking at dismissal? And it's not as a non-exhaustive list. That's what the Supreme Court
Well,
said.
We've all met the Nevada Supreme Court. They love to say, here is a non-exhaustive list.
Oh, I understand that.
Yes.
But all I'm trying to say is this, maybe, and she said there were 2 really important factors to consider.
No, she didn't say that. She said deterrence is not an important factor. She
Okay.
didn't say there were 2
All right.
important factors.
Well, here's my point, though. If I'm considering, if I don't consider dismissal, and it's a potential discovery issue, you notice I didn't say abuse yet, an issue. Maybe I can consider deterrence as one of the factors.
And I'm saying that if you should say right now, I'm tired of all you lawyers talking, I'm imposing $10,000. That's a lesser sanction. You can do an appropriate, and I'm not saying 10,000 is appropriate, but it'd be nice if I weren't in the case anymore. So so I think you could say, yes, if you were doing normal sanctions, you can consider deterrence. If you're doing a sanction that affects the result in the case, it cannot be for deterrence.
Well, I understand that, and I read it slightly different than that, because number one, for the record, I just want to make sure I'm clear that I'm not saying deterrence is the only factor I'm considering, number one. Number two, I'm looking at it through this lens. Maybe I'm not considering dismissal. I don't know yet, right? But if I'm not considering dismissal, then I can look at other factors.
Right, though it's probably striking our answer or parts of our answer that you'd be looking at.
Well,
here.
I'm not even saying that, Mr.
Right,
Polsenberg.
no, I'm just saying, the reason Johnny Riviero uses dismissal is because it was the plaintiff.
I understand.
Got it, thank
Got
you.
it. I do, I get it. I do get it.
So, Your Honor, continuing on, and
We're actually on the same page.
yeah, I didn't argue with him that time.
Then we can leave.
No, you can't leave. You can't leave. Because we're going to lunch in 5 minutes and
Your
then
Honor, can we actually break now? I have.
we can break now.
Okay, good. I have a 12 o'clock, just conference call I need to handle. And
Can he
when-
finish first?
No. When can we be back, Your Honor?
We
Judge,
can be back.
Judge, don't give a lawyer a lunch break to come up with more stuff to talk about.
I
Can
understand.
I have the PowerPoint presentation in the meantime?
No. You're not having my work product.
Yeah.
It's not your work product, you showed it in court, Judge, I need a copy of the PowerPoint presentation.
Your Honor, I will discuss providing him a copy after I'm done. I don't think I've ever given my notes or my notes in front of the court to another attorney, but I'll talk to you.
You have if you were in a case with me, can I at least have the PowerPoint presentations up to the point where you stopped?
No, because some of them I didn't use. I'll have to pick up the ones, I'll have to pick out the
He'll
ones.
give you the ones he used.
I can do that.
He'll give you the ones he used.
I can do that.
Right. Can you do it before your 12 o'clock call?
No.
What we're gonna do, we're gonna break right now.
Thank you, Your Honor.
We're gonna break right now. You guys work it out. But 1:30?
Sounds
What, 30
great. Thank
cool?
you, Your Honor.